Okay. Good afternoon. I don't know if you can hear me. Please, if you can hear me, indicate.
Hi, good afternoon.
You cannot? You obviously can. Good afternoon, sir.
Turning off my video to allow you to have better quality there.
Okay, thank you so much. Okay.
Amazing.
Okay. A very good afternoon to every one of us. Good morning or good evening, whichever clime you're joining from, but I'm presenting from Lagos State, Nigeria. And it's a bright and sunny day here in Lagos. And I'm excited to have every one of us that has
Mr. Matthias, sorry, I don't know, is it possible to get from you? Like that. I don't know, any size, we don't want to move things. It's possible, but you need
trying to mute everyone, trying to
uh,
mute every participant. So, hold on. So,
okay, can you let me give some before Friday?
okay. I don't want us to waste any time today. We'll go straight into the business of the day. My name is Caroline Igege. I'm the principal of Viola Barrister and Solicitor, the law firm that puts together this webinar. There's two men in a series of in our learning series. If you've been following me from the inception of our learning series, you know that we started with wills. We talked about why an individual should consider putting a will in place, particularly when you know that you have been blessed enough and then you have something to bequeath to the next generation. Because writing a will, it's really not for everybody. Like I said, if you've been blessed enough and you know you have something to bequeath to the next generation, you should consider one. That was the first subject we talked on when we started this learning series. Subsequently, we went on to discuss due diligence. We talked about documentation, what you need to watch out for. We've talked about perfection, why you should perfect, why an individual should perfect. Because truly speaking, without perfection, we can't even be talking of title. Perfection is registration of your proof of ownership. Because today we're dealing with proof of ownership. That is what title is all about. But not too many people understand what a title to land property or any real estate is. Some persons would naturally just think that whatever you were given during the course of the transaction suffices. But at the end of today's discussion, we will know those things that are proofs of ownership by the time we finish discussing what title to it is and what you should watch out for. Because this discussion has been what to guide against, pitfalls to avoid, what to watch against, what to guide against when you're going into real estate transaction. So on that note, having said the reason why we put together this webinar, not to create a client lawyer relationship, because really and truly every discussion that we have here are not exhaustive in themselves. You cannot use it to answer any circumstance or any legal question. What it does is to empower the individuals who attend my webinars to speak from the position of strength or the position of authority whenever they are entering into a transaction. So the need to truly engage the services of a professional cannot be overemphasized. So I wouldn't want us to say, oh, the lawyer said this and that suffices, because every transaction is unique in itself. So you cannot say, because I said title is anything that shows or that details your ownership, and then they give you a piece of paper with your name, the name of the seller and all of that. You say, this details the transaction, or it details that I'm the owner, and that suffices as title. So let us go into the nitty-gritty of our discussion today. What is title? I have said it severally while trying to introduce the topic. Anything that shows any legal document, it has to be legal document. I mean, it has to be admissible in evidence in court or anywhere where the law requires that you should tender such document. It has to be a document that is recognized by law or any legal system that you find yourself, whichever client you're joining us from. So any legal document that details who owns a piece of land or any real estate, because sometimes you get a piece of land or a bare land and then subsequently you build on it because it becomes a built-up property and all of that. So any document that details that you are the owner of any property is referred to as title. And I will just quickly delve into, maybe let's just give a little background of how we came about these documents detailing ownership. Because last time when we discussed family property, I talked about communal lands. Those lands, community lands and all of that before the Land Use Act of 1978, how land transactions were done, how the Land Use Act came to change all that practice. That was what we discussed last month. Okay, so having introduced land use all of that the last time. I'll just quickly touch on it today. Before the land use decree, all lands were owned by traditional rulers. That's why, like I said, I'm presenting from Lagos. That's why you still hear families giving out lands or families assigning lands to people till dates. What has brought about the change that the Land Use Act brought was it gave all lands to the governor of each state. And then maybe some lands were also given to the federal government. But majorly, the Land Use Act was to put the government in charge of all lands, so much so that the government or the governor now acts as a trustee for those lands, for whatever use they want to use they want to put those lands to. So before an individual can lay ownership or can lay hold to any land now, it has to go through the governor or it has to get the governor's consent. Now, there are different instruments. I actually tried to, okay, let me try to share my screen. There are different instruments that we use in land transaction. Okay, there are different instruments that we use in land transaction. We've talked about the title, that is the degree of ownership. Now there are various instruments that we use when we are assigning land, whether as first owners or as subsequent owners. There are various instruments. And the reason why this discussion has become imminent today is because there is so much going on in the world of real estate. If you reside in this part of the world where I am presenting from, Lagos State to be precise, you will see that real estate transaction is like the order of the day. Anywhere you turn to, you hear one advert or you see one advert or the order. And not too many people are informed enough to make informed decisions. But you see a lot of people parting with hard-earned money. And then when it becomes a subject of litigation, they now call the lawyer in for damage control. So what this webinars really does is to kind of make sure that those who attend are able to guide against these pitfalls in all of these modern day real estate and transactions. So we'll go back to the various instruments that we use to assign land. If you are conversant with real estate and transaction in this part of the world in Nigeria, you'll see that of recent, most real estate firms, they will advertise that they have properties for sale, whether lands or built up properties for sale. And then in the column or wherever they create for title or what they have on that land, you'll see something like registered survey. Now one begins to wonder, what does it mean? What does it mean? Because I see or I get a lot of people come for consultation and then they tell you that they want to buy or they've already bought. And then when you go through the documents, you see that in the reciter, those, please don't bother yourself with some of the legal terms that I'll be using. If it matters, I'm going to discuss it. But some of these things, they are for academic purposes. And since you are not a lawyer, maybe you can just allow your lawyer to handle those kind of things. In the reciter, you see that what was assigned or the basis of the assignment was a registered survey. And then once you see that in the reciter, you know that the individual does not really understand what proof of ownership is. Before I forget, let me quickly say this. Receipts is not a title. If you bought a property, if you bought a land or a building and you were issued a receipt, it does not suffice as a title. At best, it just shows that money exchanged hands. That is what a receipt does, because some persons have properties in some parts of the world, one where they say what they have on it is a receipt. A receipt is not a title. A receipt is not a title. So now, I was talking about registered survey. What does it mean? A registered survey, if you are buying a property and somebody tells you that he or she has a registered survey, maybe after this webinar, you should be able to ask the person, what do you mean by registered survey? To what end is a registered survey in this transaction? And what does it transfer to me if I really put my money down in this transaction? A registered survey at best is a means to an end. It is not an end in itself. What do I mean? If you have a registered survey, it just shows that you probably have taken the first step in wanting to perfect your documents. That is, in wanting to obtain what we are discussing, a title. You have not gotten a title. That you serve the meal on the table does not mean that you have eaten it. They are two different things. So a registered survey is not a title. At best, it just shows that you intend, you have an intention to get title. Now that you have known that a registered survey is not a title, what is the weight? What is the importance? To what end is this information? At least when next you are bargaining, you know what the person has. You know that the person does not have what you are actually looking for or what is tenable in law. I just hope you are hearing me because I think the network is crappy. It keeps fluctuating, but I'll try my best to kind of reiterate most of the things that I'm saying. Then we'll talk about a scission. A scission. When somebody says they are selling to you, and the pitfall, sorry, before I talk about a scission, the pitfall in buying properties with registered survey is this. It could be one or more of what I'm about to say. Now, if you get a land with a registered survey, it means that the person wants to pursue a legal title to that land. Two things could happen. The person could get it ultimately. The person could also not get it, depending on the policy of that place or depending on the policy on that particular parcel of land that you are going for. Now, if the person does not get it, maybe haven't bought from the person and you still probably insist that the person goes after his or getting her own title. Two things could happen. One, if the person does not get it, it could be that there's a policy on that place that makes that land subject of acquisition. Acquisition is twofold. The government can acquire a whole expanse of land. It could be a general acquisition or it could be a committed acquisition. And I'm sorry to say that if it's a committed acquisition, it's really bad. It's bad. That is why you see that after many years, some filling stations or some buildings are being brought down. And you are wondering, what kind of wickedness is this? After this webinar, at least you know, you have an information why those things happen. Every state or every country has its own geographical mappings. There are mappings, there are plans, building plans for every state, for every geographical location. So if one makes the mistake of buying a committed land, that is the government has committed a particular area for a project. If one goes and buy under all this registered survey when you don't know what is there, and then it turns out that is a committed acquisition, it means that any government can come up, a new government can come up, or even that subsisting government can come up and say, the project for which this axis was maps, we want to kickstart it. And they will be left with no choice but to bring down those buildings. But if, for instance, okay, if it's a general acquisition, because I have clients that have consulted me, some that have committed acquisition, we try as much as possible to still follow it up at the Surveyor General's office to see if there will be a change in policy. But for those that are bought the ones that have general acquisition, it's 50-50. the government could decide for them to come and regularize. That is, could decide that, okay, maybe since the location has been built up, people can come and regularize. Then in that instance, they could be demanding a fee or could be demanding any other form for you to regularize that transaction. There were some we had to do at Abeokuta. I think what happened there, the people had already built, but there was a government plan there. So I think when the government saw that the 99% of the area or the axis was already built up, just asked that individuals should come and regularize. And we took that up for a client. And then the process of regularization, somehow, to me, it means you buying it afresh, but you may not pay as much as you have paid the first time. So on that note, we move to excision. Now, having mentioned general acquisition, the government can now say, okay, let us excise. Is this, the word excision, it doesn't have a different legal meaning. It's the English meaning. That is to cede some parts or to take out some parts. Now the government will now say, okay, since we have a general acquisition on 1,000 square meter, let us excise 50 square meter to the original owners, which is the community that they took the land from. You know, for every land, when we discussed the last time, we were talking about family land. Every family, the first settlers, they lay hold of those axes. So every land was first of all a communal land before the land use acts. So the government can ask, okay, let us excise some parts to the community. It is those excised parts that these community people, maybe through real estate firms, will now sell. And then when you ask them what their title is on the land, they tell you that they have a cession, that they have a cession on it. I want to believe that we are getting value. Please, if you are getting value after the webinar, try as much as possible to send us your feedback. And if you have any other topic that you want us to discuss subsequently, also let us know. Our informations are on the flyers that we use to invite you for the webinar. You check there, you see my personal mail or the office mail. But my personal phone number is also there. And then you can also check for me on LinkedIn. I'll be glad to connect. So we're talking about a decision, and I said the government or the governor could say, okay, let us give back some parts of these lands to the community. And it is those parts that they've excised that these people sell. And then when you check their advert and you ask them, what is your title? They will tell you a section. That is, the government has given them that part of the land that they are selling. Well, you are safe or almost safe. Because on a excision, they could now go ahead and probably gazette the excision, or they'll get a C of O on that excision. But most of these communities, or most of these traditional rulers or real estate firms, because the real estate firms, they actually buy from the community leaders. Now, most of them don't want to part with money. These are privileged information. Anyway, they don't want to go ahead and get certificates of occupancy, because the process of getting certificate of occupancy demands that you part with some money, and then you have to pursue your application and all of that. So they'll just package it, and then they transfer it to unsuspecting individuals, and then you buy. So maybe what can now come up in that scenario is what we call double consents. That is, you have to perfect for the previous owner before you start perfecting for yourself. In that case, a gazette, if the excision is already gazetted, that is, a gazette is just a book of records, government records, a book that contains government records. If you come across anyone, you see all these gazette number 24 in volume 36, 1994. It shows the different villages. It shows the different parcels. It will show the coordinates, all the lands that have been excised. That's the ones that have been given back to the community. And then the government policy statements on those axes. That's what a gazette is. So if they tell you that their title is a gazette, it means a gazette An excision is one step away from gazette. When a land has been excised, the government will put it in its record book, which is now a gazette. So when they now tell you that it's a gazette they have, it still means that the title is not yet perfect. Then it still needs to perfect. We're still going somewhere. Is it that they are going to obtain a C of O, or they are going to obtain a governor's consent? So, having talked about excision and gazette, we now come to the almighty certificate of occupancy, because that's the one that most of us are conversant with. Now, what is a certificate of occupancy? Because this is what the law recognizes. Certificate of occupancy or governor's consent. Now, a certificate of occupancy details every information of the owner of the land. That is why sometimes when you engage us to do search for you, the search report will normally show who the owner is, who the address of the owner at the time of perfecting the certificate of occupancy, the size of the land, the survey plan number, sometimes the coordinates, and you know, all of that in our search report. That is what the certificate of occupancy shows to you. That's what it shows to you. So for every land, after the land use act, for every land, if you are the first settler, that is, if you are the first person buying that land and wanting to perfect with the governor or the government of the state, whether you bought through a cession or it was a deemed grant, because apart from Section 22 of the Land Use Act that talks about you obtaining governor's consent to subsequent transaction, there's an aspect of the land use charge. Sorry, it's not land use charge. The Land Use Act. Land use charge is a different thing. The Land Use Act, there's an aspect of the Land Use Act that talks about deemed grants. Because every land that was given back to the community, or every land that the community leaders have given out before the commencement of the Land Use Act, they were not revoked. They were deemed grants or deemed as granted. So that clause or that provision of the Land Use Act just kind of makes it or justifies the ownership of land before the act was promulgated, or before the decree. It was a decree before it became an act. Anyway, so I was talking about the certificate of occupancy. Why should you perfect? Why should you get a C of O, or why should you get the consent of the governor to subsequent transaction? The certificate of occupancy is if you are the pioneer, that's the first owner of that land. That is, if there are no state records, if there are no records in the lands registry or the Ministry of Land, whichever one is applicable in the clime where you are joining from. If there are no records, state records showing ownership on that land, and you are the first to take on or embark on the process of documenting it with the state government, they will issue you a certificate of occupancy. But if you are a subsequent purchaser, you are going to get a governor's consent. So really and truly, none of them is, you cannot say that the certificate of occupancy is more powerful than the governor's consent. It just shows the stage in which you came into the transaction. If you are the first person to embark on documenting that particular piece of land or property with the states, the lands registry or the ministry, whichever one is applicable, what you are going to get is a C of O, a certificate of occupancy. But remember that the certificate of occupancy does not automatically give you, is a leasehold. Since the Land Use Act came into play, every land belongs to the state governments or the federation, whichever one is applicable. In Nigeria, you'll see that the flyer said to avoid when buying properties in Nigeria. So now, what the certificate of occupancy does is to give you a leasehold for a term of 99 years, less 1 day. You may not bother yourself with that. But if you engage a professional or the services of an experienced lawyer, the lawyer will be able to know the lifespan or the term remaining in every C of O. C of O is not a life document. If you read through, if you have one and you take the time and the pain to go through, you discover there is a lease for 99 years. So depending on when it was dated, that does not mean that when it expires, they will revoke it. Because really and truly, nothing has